Has your employer asked you to sign a non-compete agreement? In many competitive industries, signing a non-compete is simply part of finalizing a job's contract. Of course, you want to know exactly what you're agreeing to before you sign any work-related documents. What exactly is a non-compete agreement, and what does it mean for you and your career? In a nutshell, this type of contract prevents employees from sharing proprietary information or working for a competitor for a specific amount of time after the employment relationship ends. While it may seem reasonable for employers to want to prevent their workers from taking away customers, clients, and other employees, there are downsides to such agreements, particularly for the employee. Non-compete agreements can give employers the power to control former employees long after they leave the company. That's why some states don't allow non-compete agreements at all, and since 2000, litigation emanating from non-compete agreements has tripled. However, non-competes in Pennsylvania are currently legal and quite common. Pennsylvania's House Bill 1938 specifically seeks to ban non-compete clauses, but the future of this bill remains uncertain. Since you may encounter an employer who requires you to sign a non-compete agreement when working in PA, you should know what to look out for before you sign. If any of the clauses seek to severely limit your current or future job opportunities in any way, this may serve as a red flag. Remember that when it comes to your career, you can expect many changes within the upcoming years. Your career goals may change, your company may terminate your employment, or you may even decide to open your own business. Ask yourself whether the non-compete agreement in question will have a permanent or detrimental effect on your career. While your employer may defend this contract as beneficial to the entire company, a growing body of evidence suggests that non-compete agreements are often deployed in a way that lacks fairness and transparency. Since these clauses can hurt your ability to build your career, it may not be in your interest to agree to them. Rather, you should consider negotiating any key job-related stipulations with the assistance of an attorney. With the proper legal help, you'll find it easier to reach a reasonable resolution. If you've already signed a non-compete agreement and it's restricting your ability to access work, it's important to speak with an attorney. Reviewing how enforceable your non-agreement is will be crucial too. If the restrictions of your contract are extremely limiting, a court is unlikely to enforce these conditions. In certain cases, termination may render the agreement unenforceable. In the case of Insulation Corporation of America v. Brobston, the court deemed that a sales representative fired for poor performance was not a competitive threat to the employer. However, it is much easier to negotiate a non-compete clause than it is to navigate the process of breaking one. If you're considering a new job and need support, consult an attorney. A professional can help you break down and avoid any clauses that may potentially restrict your career in the future. For questions regarding a non-compete, contact Weisberg Cummings today for a free consultation.